If you own a business, you need to give serious thought about what would happen to that company if you were to die, or if you were to become incapacitated. What if you're in a coma, or what if you have Alzheimer's or something like that? What's going to happen to your company? What's going to happen to your family? And that's why you need to plan now and prepare for the worst so that you protect your most valuable assets, your loved ones. And when you're talking about a company, one of the first things that you need to consider doing is life insurance. If you've got a company and you were to die and you're the main person in charge of that company and nobody else can run it without you, then you need to have life insurance that's going to provide for your loved ones if you die. And then maybe your family's able to sell that, maybe not, because without you, maybe the company doesn't survive. But if it does survive, the next issue is what happens to the company. If you die, is it going to go automatically to a loved one because you have a trust that provides that your loved one inherits it without a probate? Or if you don't have a will or a trust, is it going to go by intestate succession to whoever the state of Arizona decides is going to inherit your assets? So what you should do is you should plan in advance for the worst case scenario, have a will or trust that determines who inherits your assets if you die. Now, also, when you have a company that's got multiple owners, that's when the company needs to have a buy-sell agreement signed by all the owners, and that buy-sell agreement provides what happens if somebody dies. So if the company has an option to buy or is required to buy the interest of a deceased person, then that means the company is going to buy, but the question is, what's the purchase price? Because as we all know, whatever a company's worth today, it's not going to be worth the same amount a year from now or 5 years or 10 years from now. So what we recommend in our buy-sell agreement is that the value of the company that's going to be purchased is going to be determined by an appraisal taken after the death of the person. We have a recommendation of 3 qualified appraisers who are able to value a business. You don't want your real estate agent to value your business. You don't want your CPA to value your business because they don't have the experience necessary or the knowledge necessary to provide an adequate and fair and reasonable valuation. You want to get somebody who has the proper credentials and experience valuing business. There's a death or a buyout because of disability or something like that. So when we do a buy-sell, we actually have 3 extremely qualified appraisers that we recommend that our clients can pick from if it's necessary to do an appraisal. So bottom line is prepare for the worst, protect your loved ones by having taken the steps necessary to make sure that if something happens to you, that they're going to be taken care of. If you own an interest in an LLC, you need to think about and plan and take action to prepare for what happens if you were to die. Because if you die, your interest is going to go somewhere. It's going to be inherited by whoever the state of Arizona selects if you don't have a will or a trust. Or what you should do is you should have a will or a trust that provides who inherits your interest in the company if you die. Now, the difference between a will and a trust is a will requires the company to go through a probate unless it's not worth very much money. And a probate can be time-consuming, expensive, and it's a superior court lawsuit. And if you want to avoid that, which most people do because they don't want to they don't want to have the family have to pay the cost of the probate, the way to avoid a probate is to create a trust. So the benefit of the trust then is that there's no need for probate. Your company transfers automatically to the person or people that you've named in your trust agreement. And you can have alternate takers. For example, you could say if you die, your company goes to your spouse, but if your spouse is deceased, then it goes to your children. If you're not married, you could say that if you die, your company goes to your children. But you could say that if both children are deceased, then the company will go to somebody else. So you can have alternate takers in your trust agreement so that ultimately the person or people you want to inherit your business are going to be set forth in your trust agreement, because you don't want the company to be a forgotten asset that just sits out there and gets inherited by the wrong person. Because maybe you don't want everybody to inherit your company. Maybe you want your company to be inherited by a specific person. So in your trust or your will, that's where you're going to designate specifically who inherits your company. As a business lawyer, we've got a lot of clients who are in LLCs that have multiple owners. And when you have a company that has multiple owners, particularly if the owners are not family members, it's extremely important that the owners sign a contract called a buy-sell agreement. And what a buy-sell agreement is, it's a contract between the owners that provides on the occurrence of a certain event, we call that a triggering event, that will cause one of the owners to be bought out or give the company and the other owners an option to buy out that particular owner. Now, a common triggering event is death. So if somebody dies, if one of the owners dies, then the company can be obligated to buy the interest of that deceased person, or the company can have an option to buy the interest, and the other owners can have an option to buy the interest of the deceased person. But a buy-sell agreement does a lot more than just deal with what happens on death. We've got in our buy-sell agreement 19 possible triggering events that can cause a buyout. For example, our clients can pick and choose from the list, so they can say they want to buy out if there's a bankruptcy. They want to buy out if somebody loses their mental capacity, or if there's a divorce and the wrong spouse ends up owning the company, or if somebody gets found to be a thief stealing from the company, or if they disobey and don't follow the obligations set forth in the buy-sell agreement. So there's about 19, as I said, 19 triggering events that the people can pick and choose from that can cause a buyout. Retirement, there's another one. What happens if somebody reaches retirement age? So in the buy-sell agreement, we can add any additional triggering events that you want. So if you want to say if somebody buys season tickets to the Arizona football Cardinals, then they can be bought out. So as long as the triggering event is not unlawful, we can put that in the custom buy-sell agreement that we prepare for you. But it is important, if you've got a multi-member LLC, the bottom line is, what happens if somebody dies, or what happens if something bad happens? How is that person's interest going to be dealt with? Is it going to be bought out, or is it going to be continue to be carried through the company? We prepare buy-sell agreements, and the purpose of the buy-sell agreement is to protect all of the parties that are owners to the company. And so we're happy to answer questions. If you have questions, give us a call or set up a free consultation by going to our calendar at www.keytlaw.com/calendar. If you have questions, send an email to me, and I'll then respond and give you a link to my article that I wrote about why you should have a buy-sell agreement, and also a link to our buy-sell agreement questionnaire, because we make it really easy to hire us to do a buy-sell agreement. All you have to do is answer the questions on our buy-sell agreement online form, and then when you click the submit button, our system sends an email to you and to us. So we've got all the information we need to prepare your custom buy-sell agreement.